Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. Pursuant to notice, I now call up H.R. 4170 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4170, to amend the Foreign Agents Registration Act of 1938 to promote greater transparency in the registration of persons serving as the agents of foreign principals, to provide the Attorney General with greater authority to investigate alleged violations of such act and bring criminal and civil actions against persons who commit such violations, and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. I commend Representative Johnson for introducing H.R. 4170, the Disclosing Foreign Influence Act, a narrowly focused bill aimed at requiring greater transparency when entities advocate on behalf of foreign governments in the United States. The Foreign Agents Registration Act, called Fara, was enacted in 1938 to require individuals, groups, or organizations advocating on behalf of foreign governments to register and report to the Department of Justice on a periodic basis. Such disclosures allow the American people and their law enforcement agencies to evaluate the statements made by registrants in light of their function as foreign agents in the U.S. However, several loopholes exist in FARA as currently codified, loopholes that have been highlighted by independent agencies from Inspector General offices to the Government Accountability Office. The Justice Department's National Security Division Inspector General concluded in a 2016 report that the federal government currently lacks both the comprehensive enforcement strategy and, more importantly, the basic tools to obtain the information necessary to enforce FARA. That report followed the Government Accountability Office's 1980, 1990, and 2008 reports that all recommended the federal government be given a demand authority to obtain information necessary to FARA's enforcement. Answering the call for such enforcement authority is Mr. Johnson's bill before us today. The bill grants the Attorney General the same civil investigative demand authority he currently has to investigate false claims made to the federal government. This demand authority is a type of subpoena that allows the Department of Justice to obtain documents, require responses to interrogatories, and take depositions. 28 of the bill's 34 pages simply replicate the provisions of the Civil Investigative Demand Authority in 31 United States Code Section 3733 and codify those same provisions in the context of FARA investigations. The bill also eliminates a loophole that currently allows entities to forego registration under FARA when they register under the Lobbying Disclosure Act of 1995. Those who advocate for foreign governments and entities in the United States should register under both that act and FARA when appropriate, as this bill requires. The bill also requires the Department of Justice to develop a comprehensive strategy for administering and enforcing FARA, including setting standards for the timely review of FARA filings and the encouragement of coordination between national security agencies and law enforcement. Senator Grassley has introduced companion legislation in the Senate, and I look forward to working with all of my colleagues to see these common sense transparency provisions enacted into law. It's now my pleasure to recognize the ranking member of the committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. H.R. 4170, the Disclosing Foreign Influence Act, appears to be a good faith attempt to strengthen the Department of Justice's ability to enforce the Foreign Agents Registration Act of 1938, or FARA. Under FARA, an agent of a foreign principal must register with the Department, file any informational materials that he or she has distributed within the United States on behalf of a foreign principal, and maintain records of his or her activity. Among other things, the bill amends FARA to eliminate an existing exemption for individuals who have already registered as lobbyists pursuant to the Lobbying Disclosure Act of 1995. It also gives the Department of Justice the authority to issue civil investigative demands, or CIDs, which are effectively administrative subpoenas that the Department may issue to demand documents, interrogatory answers, or oral testimony from any persons with information relevant to an investigation. The bill's CID provision appears to be substantively similar to the CID provision in the False Claims Act. I appreciate the work that Representative Mike Johnson has put into crafting this legislation, and I share the goal of ensuring that FARA is enforced properly. It is understandable why many public interest groups would support this bill, including many that I admire and respect. H.R. 4170, however, is not yet ripe for markup, as it might raise several constitutional and policy questions that should give us some pause before we move forward. I note that the Judiciary Committee has held no legislative hearing on this bill and does not appear to have held an oversight hearing on Farah since 1991. By bringing this bill straight to markup without a hearing, the majority has made it very difficult to determine the extent of these concerns or whether or how any of them can or should be resolved. A hearing on this bill is critical for members to fulfill their obligations to legislate properly. There are also other proposals, such as a bill offered by Mr. Cicilline. We should explore various options before deciding on a course of action. There's no good reason not to have a hearing, and proceeding without one risks unintentionally introducing new errors into existing law. Turning to the substance, H.R. 4170's CID provision may raise Fourth Amendment and other constitutional concerns. We have heard informally from the American Civil Liberties Union, the Center for Democracy and Technology, and the National Association of Criminal Defense Lawyers, and I have a letter here which I'd ask unanimous consent to insert into the record from the National Association of Criminal Defense Lawyers.
Without objection, will be made a part of the record.
Thank you. We have heard from these organizations that the use of CIDs may effectively be an end run around the Fourth Amendment, particularly where, as in the case of Farah, criminal prosecution and sanctions may result from an investigation. To obtain documents and other evidence in a criminal investigation, law enforcement officials must get a search warrant issued by a judge after a showing of probable cause that a crime was committed, and that items connected with a crime are likely to be found at the location specified in the warrant. The CID language in this bill, however, appears to allow law enforcement to obtain such items without any prior judicial authorization, thereby circumventing an important constitutional limit on government authority. I recognize that the bill's CID provision was largely taken from a long-standing provision in the False Claims Act, and I appreciate that it includes and even builds upon that statute's procedural protections for the targets of CIDs. I note, however, that the False Claims Act carries no criminal penalties and that the False Claims Act investigations are purely civil in nature. By contrast, Farah investigations may be criminal in nature when there's been an alleged willful violation. Thus, the constitutionality of the use of CIDs in the False Claims Act context may not be the same as they used in the Farah context. The bill may also raise potential due process concerns, for while the bill allows a target of a CID to have counsel present during oral testimony, it does not require that a target be informed of their right to have counsel. In addition, although a witness may refuse to provide testimony by raising his or her privilege against self-incrimination, the bill's CID provision allows the Attorney General to seek a court order compelling testimony in response to the raising of such privilege if it is in the public interest to do so. And such testimony may still be used to prosecute an individual for perjury or giving a false statement, if not for the underlying Farah violation. Finally, I note that a coalition of nonprofit groups that includes the American Bar Association and the International Center for Not-for-Profit Law have expressed concern about what they believe are Farah's overly broad and vague definitions of, quote, agent of a foreign principal and, quote, foreign principal. They believe that strengthening enforcement of Farah without addressing these concerns, together with the threat of criminal penalties, risks chilling important civil society work both in the United States and abroad. While I make no final judgment on the merits of these and other concerns, it is worth our effort to hear them out before proceeding to markup, and a hearing would have been beneficial to that end. I would ask that we postpone today's markup until we have the opportunity to hear from and examine outside experts and interested stakeholders on the record so that we can craft legislation that can truly have strong bipartisan support. Before I yield back, I must note one issue that ought to be at the forefront of the Judiciary Committee's agenda today instead of this bill, and that is President Trump's unconscionable and racist comments last week. It has been widely reported that during a White House meeting to discuss a proposed bipartisan immigration deal, the President made a number of racist and offensive comments, including, when discussing the inclusion of Haitians in the deal, asking, quote, Haitians, why do we need more Haitians? Take them out. When referring to African countries as, quote, shitholes, unquote, and suggesting that instead of accepting immigrants from Haiti and Africa, we should instead bring in more people from countries like Norway, with the clear implication that he was referring to countries that are predominantly white. I ask all my colleagues on both sides of the aisle to repudiate these comments immediately. I hope they will join Mr. Richmond, the chairman of the Congressional Black Caucus, myself, and many other Democrats, including many members of this committee, in supporting a formal resolution of censure condemning the President's hateful, discriminatory, and racist statements. This is a time when Congress should speak with one voice, and I hope we will seize the moment. I know that the White House has disputed whether the President used the specific vulgar term I referenced earlier, but they have not disavowed the racist sentiment behind it. At a minimum, I hope we will reaffirm this nation's historic commitment to diversity and its long history as a beacon of hope and refuge for those who need its protection. As we condemn the President's comments, we must also not lose sight of the fact that we are inching closer to a deadline that puts 800,000 dreamers at risk of being expelled from the only country they have ever known. It is imperative that we pass the DREAM Act without delay and without the hateful and divisive rhetoric flowing from the White House. I thank you, and I yield back the balance of my time.
I would now like to recognize the sponsor of the bill, the gentleman from Louisiana, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman. One of the worst-kept secrets in Washington is how frequently lobbyists violate our foreign registration laws by accepting millions of dollars from foreign principals without disclosing a thing about those relationships. More Americans are becoming aware of the problem, especially over the past year, since specific focus and attention has come to light on two high-profile failures to register under the Foreign Agents Registration Act, commonly referred to as Fara. It is no coincidence that a number of foreign agents have recently begun to register under the Fara statute retroactively in an obvious effort to avoid prosecution for their prior activities. Since its enactment in 1938, the Foreign Agents Registration Act has served as a critical tool to monitor and track individuals, groups, or organizations who advocate on behalf of a foreign government within the United States. These entities who lobby on behalf of a foreign government or principal in a political or quasi-political capacity must adhere to registration requirements and report necessary information to the Department of Justice. Requiring these types of disclosures reveals relationships with foreign entities that help disclose important information to the U.S. government and to the American people, so we can responsibly evaluate the activities of these individuals and their function as foreign agents. Unfortunately, as a result of numerous changes and modifications since its inception in 1938, the Foreign Agents Registration Act has numerous loopholes and long-standing deficiencies that allow foreign agents to evade FARA disclosure requirements and instead simply register with very minimal informative disclosure standards under the Lobbying Disclosure Act. A recent series of recent scandals in which persons lobbying on behalf of foreign governments failed to register and disclose the foreign interests they represented mirrors many of the shortcomings of FARA identified by the Inspector General's Office of the Department of Justice. Similarly, in 2014, a series of scandals involving high-profile groups in Washington led Congress to direct the Inspector General to conduct a specific year-long review into the deficiencies of this law. These loopholes in question open the door to problematic activities at the highest levels of government, and without the necessary investigative tools, allegations of FARA abuses will remain unanswered. There are 4 overarching areas which the DOJ, Office of the Inspector General's reports, 14 recommendations, and the historical evidence all highlight: enforcement strategy, subpoena authority, problematic exemptions, transparency, and oversight. The legislation before the House Judiciary Committee today, H.R. 4170, the Disclosing Foreign Influence Act, uses carefully crafted legislation based on the historical evidence to address each area with real reforms. By doing this, we'll achieve necessary but balanced progress. And as our chairman just articulated, this is a matter of common sense. This bill seeks to correct clear violations and close the unnecessary loopholes to increase transparency so the American people can rightfully identify what foreign principals are attempting to influence our U.S. policy. Specifically, my legislation remedies ambiguity in the law and updates the filing threshold for disclosing requirements by aligning fair reporting to the Lobbying Disclosure Act timeframe. H.R. 4170 also closes major carve-outs and loopholes, such as eliminating the LDA exemption that allows foreign agents to avoid FARA registration. The Department of Justice has stated that increasingly, foreign state-owned companies that qualify for current exemption are increasingly a cause for concern in respect to national security. To ensure full compliance under this legislation, the Department of Justice has granted civil investigative demand authority to investigate possible violations of those who should be registered under FARA, while also codifying over 50 years of improvements and safeguards that have been put in place for CID authority to prevent any government overreach or abuse. These 2 reforms alone establish sorely needed reforms to enhance the enforcement of the law and transparency, and have been publicly supported by major civil liberties groups as necessary reform. To that end, I'd like to insert into the record a letter of support for this bill by a coalition of civil liberties groups, Mr. Chairman. Let me summarize by reiterating the important purpose of what we're doing today. This legislation will finally put an end to the major ambiguities and exemptions that have been exploited by foreign nations to maneuver around our laws and lobby the federal government without transparency. The The American people deserve to know when foreign adversaries are attempting to meddle in our domestic affairs, and my legislation will ensure we have that information. I'd like to thank the members who are co-sponsors of this important bill, and I specifically wish to thank Congressman Richmond and Bishop for working with me to make this bill a bipartisan effort. With that, I yield back, Mr. Chairman.
Chair, thanks, gentlemen. Are there any amendments to H.R. 4170?
Mr. Chairman.
For what purpose the gentleman from Louisiana seek recognition?
Sorry, Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 4170 offered by Mr. Johnson of Louisiana. Page 32, beginning line 3.
Without objection, the amendment is considered as read, and the gentleman is recognized.
Mr. Chairman,
for 5
point of
minutes on this
order.
amendment. Purpose of the gentleman.
Is it not appropriate to ask whether or not any members of the opposition wish to have strike the last word before you go again to a Republican member of this committee for an amendment? We haven't had an opportunity to make opening comments on the bill.
The gentleman, once you can move to strike the last word at any time.
But we have a custom of going Republican, Democrat, Republican, Democrat.
We checked to find out if the ranking member of the subcommittee wished to make a statement. It was advised that he did not, so we then went to the amendment offered by the
I
gentleman
sought
from Louisiana.
recognition, Mr. Chairman, to move to strike the last word so I could make comments on the bill, and I'm asking.
We were not informed ahead of time, but we'll consider the amendment. You can move to strike the last word at any time.
Thank you, Mr. Chairman. As evidence included in the 2016 DOJ Inspector General audit of the Foreign Agents Registration Act showed, this is clearly an important area where independent oversight is needed, and a review by the Department's implementation of the statutory requirements in this draft legislation, if they were to become law, will be beneficial. The technical modifications in my amendment include adding a 120-day time frame for completion of the development and implementation of the comprehensive enforcement strategy. Second, it removes the indefinite open-ended time period of the Inspector General oversight that is mandated by this section, namely requiring the DOJ IG to conduct a, quote, regular ongoing review, unquote, of the areas described in sections 4B1A and 4B1B. The DOJ IG already has the authority to follow up on previously made recommendations or reported issues. Such a statutory provision would require the IG's Audit Division to continually obligate its limited resources to review these FARA provisions year after year, even if a risk analysis does not support continuing to conduct such a review. Lastly, my amendment would add a requirement for the DOJ to include information in its annual report to Congress detailing the usage over the preceding year of the authority granted to the Attorney General by this Act to issue civil investigative demands. We believe this will be extremely beneficial in determining if the law should be reenacted after its 5-year sunset provision. Specifically, the DOJ Inspector General would be required to produce within 1 year following enactment of this legislation a report detailing the number of CIDs issued, description of the nature and the alleged violation, description of the documentary materials, interrogatories, and testimony required by CID, the number of times the Attorney General filed in a district court of the United States a petition for an order for CID enforcement, a description of the results of CID demands issued, and whether the Attorney General subsequently filed alleged violations of FARA, and any further pertinent information as necessary. I encourage my colleagues to support, again, this common sense amendment, and I yield back.
For what purposes, gentleman from New York seek recognition?
Mr. Chairman, this amendment seems fine, and I yield to the gentleman from Rhode Island.
I thank the gentleman for yielding. Over the past year and a half, it has become clear that foreign governments are seeking to exert pressure on American public opinion and on lawmakers in ways that do not comply with U.S. law. Last fall, our intelligence agencies concluded that the Russian government engaged in an extended influence campaign to interfere in our presidential election. In the course of the investigation into the election hacking, at least 2 Trump associates have been found to have violated required reporting under the Foreign Agents Registration Act, or FARA. And we know that there are almost certainly more cases where Americans have not properly registered as foreign agents. I have grown increasingly concerned about foreign interference in the United States and have concluded that current enforcement of the Foreign Agents Registration Act is not sufficient. And that's why last June I introduced bipartisan legislation along with Congressman Gates here in the House, and bipartisan legislation was introduced in the Senate as well by Senators Shaheen and Senator Young that would give the Department of Justice additional authority to investigate FARA cases. The bill we're taking up today shares some similarities to the bill I introduced last summer, and it seeks to address the same problem. Unfortunately, as the ranking member said, we've had no hearing on this, where we could examine the differences between the Johnson legislation and the bipartisan bicameral bills previously introduced. But nonetheless, the American government has really taken very limited action to protect against Russia's ongoing efforts to undermine our institutions and indeed our democracy. The American people deserve to know when they're being given information backed by a foreign government, and in fact, it's already required under the law. The Foreign Agents Registration Act requires persons and organizations advocating on behalf of a foreign government in the United States to register and regularly report to the Department of Justice so that the American public can clearly identify foreign propaganda and other information operations designed to influence U.S. elections. But unfortunately, as we've clearly seen over the last year, law enforcement does not have the tools it needs to effectively enforce Fara. Right now, the Justice Department must have enough evidence to bring charges in a civil or criminal proceeding in a Fara case before they can compel the production of documents. It's a catch-22. The current law hamstrings the ability of law enforcement to untangle the complicated network of shadow organizations, corporations, and boards that governments can utilize to hide their activity. This legislation, like my own, gives the Justice Department new authority to investigate potential violations of the Foreign Agents Registration Act. I think enhancing the Department of Justice's investigatory power is clearly needed in FARA cases, but I'm mindful that we cannot overreact and compromise the civil liberties of Americans in our quest to protect our democracy. Therefore, while I'm supportive of the intent of the bill, I will offer a number of amendments that I believe will clarify the scope of the new investigatory authority and improve the reporting requirements so that we can have transparency in foreign activity, the ability to investigate when we believe there are people who are skirting the law, yet maintain the fundamental civil protections that are the bedrock of our democracy. And I think this is obviously a very serious issue. There are some significant differences between the legislation which is introduced in the House and the Senate and the Johnson bill. And I'll just end where I began. I think it's lamentable that we didn't actually have a hearing where we could examine the implications of some of this language and the differences between the bipartisan bill in the Senate, the bipartisan bill in the House, and this legislation. And I'm going to attempt to do that by way of offering amendments to accomplish the same objective, but it's certainly not the most efficient way to do business in our committee. And with that, I thank the gentleman from New York, and I yield back to him.
I thank the gentleman. I yield back.
Question occurs on the amendment offered by the gentleman from Louisiana. All those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it. The amendment is agreed to. Are there further amendments? For purpose of the gentlewoman from Texas seek recognition. The clerk will report the amendment.
Amendment to H.R. 4170 offered by Ms. Jackson Lee of Texas. Page 2, line 2, strike Disclosing Foreign Influence Act and insert.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
Thank you very much, Mr. Chairman. Let me join with my colleagues on the importance of process in a committee that is as august and esteemed as a judiciary committee as it relates to the adherence to the rule of law and the Constitution. This particular act, the Disclosing Foreign Influence Act, to amend the Foreign Agents Registration Act and the Lobbying Disclosure Act, is an important policy. I join with my colleague from Rhode Island to indicate that if there ever has to be regular order, it should be here in the Judiciary Committee. I'm reading from the letter from the National Association of Criminal Defense Lawyers, and it indicates that there are some possible constitutional problems with this particular legislation because it grants federal authorities the power to compel the production of documents and force the testimony of the targets of criminal investigations without any prior showing of probable cause or court approval. It eliminates exemption, and it grants civil investigation authority to the DOJ. A number of questions that should be raised. My amendment, however, seeks to emphasize the long trail of problems with this administration and the fact that this particular committee has chosen to offer amendments or legislation that have had no hearings, that have not taken into consideration Mr. Cicilline'z bicameral and bipartisan legislation, but have sought to interject in the waning hours of this week this particular amendment or this particular bill. I offer to change the title of the bill to No More Manafort or Michael Flynn Act, because this committee has yet to investigate and to look at the elements of obstruction of justice. You've yet to call any witnesses as the Judiciary Committee in the Senate or the House and Senate Intelligence Committees. We have yet to hold a hearing on the constitutional parameters of these issues of obstruction of justice or Russian collusion or the security of elections as we approach 2018. As indicated, we have not held a hearing on Fara, and the last possible hearing was in 1991. This is a very complex issue. The appropriate way to legislate on this issue is to first hear from experts. Hiding from the elephant in the room is not the proper way to legislate. Fara and the Special Counsel investigation into Russian interference in the 2016 presidential election has not even been addressed in this committee. To emphasize why I chose to name it in this way, for example, the former National Security Advisor Michael Flynn retroactively filed a Fara registration with the DOJ that revealed he was paid more than $530,000 to serve as a lobbyist for the Turkish government while serving as a Trump campaign advisor. The former President Obama warned President Trump of General Flynn, and so did Deputy Attorney General Sally Yates. But in disregard for the sanctity of government and the integrity of government, the Trump administration refused to acknowledge the danger that might have been caused. Through his firm, Flynn Intel Group, Flynn was hired by the Dutch company, Innovo BV, which is owned by the prominent Turkish businessman who has strong ties to the Turkish government. There's a long list which included in his being hired a proposal of $15 million plot to kidnap the dissident and fly him to an island prison in Turkey, and that is, of course, the individual that is housed in Pennsylvania. We know the story of Manafort. We also recognize that this committee has had no hearings on the DREAM Act or the status of DACA or the reforming of the immigration system, and we've had no constitutional hearings on the question of censor and the words that were said by the President of the United States that disrupted a whole long history of alliances with the continent of Africa and the countries of Honduras, Haiti, El Salvador, as relates to the TPS. So I believe that this particular committee has not done its job, and it certainly does not adhere to regular order. So if we are going to pass this bill by the majority, then I would ask that it be named the No More Paul Manafort or Michael Flynn Act, since the most conspicuous and notorious individuals who have not properly registered are certainly these individuals, and the most conspicuous disregard for regular order is the Trump administration refusing to acknowledge the insight of the Deputy Attorney General of the Department of Justice, who has only the concern to uphold the law, and the former President of the United States of America, whose only desire is to ensure that the United States comports with the law, meaning the government, and that the people of the United States have their rights. So I would offer this amendment so that maybe it can be a truthful bill, and as well, I would offer this amendment in the context that we have not done in regular order the important work of providing status for Dreamers, 800,000. We have not done comprehensive immigration reform. We've not begun to question some of the very important issues that the Judiciary Committee should be concerned with, dealing with obstruction of justice and the question of election security and Russian collusion in the last election. With that, I ask for the support of the Jackson Lee Amendment.
For what purposes, gentlemen from Louisiana seek recognition?
Thank you, Mr. Chairman. I oppose the amendment. Clearly, it's an effort to unnecessarily politicize what is truly a bipartisan bill based on common sense and intended to uphold the rule of law. You know, there's a well-documented history of inadequate compliance with FARA that goes back to 1974. We've had repeated reports by the GAO, for example. All this is cited in the committee memo today. 1974, 1980, 1990, 2008, and most recently the DOJ's OIG report in 2016, pointing to the urgent necessity of the changes that we're bringing today. I requested permission to enter into the record earlier in my opening statement this letter from center-left groups that begins, "We are writing to encourage all members of the House Judiciary Committee in bipartisan spirit to support and co-sponsor the Disclosing Foreign Influence Act, because this legislation would provide desperately needed improvement to the Foreign Agents Registration Act to strengthen monitoring for compliance and enforcement of the Act." And it's signed by a number of groups, including the Campaign Legal Center, Citizens for Responsibility and Ethics in Washington, Common Cause, Issue 1, the Project on Government Oversight, Public Citizen, the Sunlight Foundation, and noted academics. So, you know, it's unfortunate that we would insert politics into this. This is a measure to clean up the system, to provide necessary disclosure for the American people. And for that reason, it's a bipartisan measure that I think that all members of the committee should enthusiastically support. With that, I yield back.
The gentleman yield. Would the gentleman yield? I
Yes,
thank
sir.
the gentleman for yielding, and I share his sentiments. You know, this measure is based upon a lot of information that is compiled over a long period of time. It's associated with a similar measure in the United States Senate. You could name other people on both sides of the aisle. John Podesta comes to mind, that you could add to this title. Would you really want the long-term title of a bill to reform our laws and require respect by foreign governments to comply with and report, and people representing them to report their actions, to have a name like that instead of a neutral name that makes it clear that it applies to all people for all time? So I join the gentleman in opposing this amendment. But first, the gentleman from Georgia seek recognition.
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Well, I rise in support of this name change for this bill. And I would note that the reason that the minority comes forward with proposals such as this is kind of almost like a protest, because we get jammed with this kind of legislation repeatedly and habitually, failing to go through regular order on bills that are very important. It's no doubt that the Fara bill is very important. It's very serious. It's clear that this 1938 law needs reform. It needs a revision. It needs attention by this committee, but not in the way that this bill has been brought to us. It's been brought to us outside of regular order. It's been brought to us for a markup. We've not had any hearings on it, no witness testimony. We've just had legislation drafted, and it's being shoved down our throats right now. And the least we can do is try to rename it so that it gives to the public the semblance of importance that it should have. I mean, a lot has changed since 1938. We have now entered the information age in a global economy. It's no question that the circumstances that were anticipated in 1938 were unimaginable at that time. The life that we're in right now needs to be soberly addressed, and the circumstances that this legislation fits within need to be addressed with respect to today's reality. So what is today's reality? Today's reality is that since 1966, 50 years ago, we've had only 7 cases brought by the Department of Justice prosecuting persons accused of failing to register as foreign agents. And out of those 7 cases, there's only been 1 successful prosecution. So 7 cases in 50 years, 1 successful prosecution. Now all of a sudden we have the Manafort and Flynn situations that come up. It highlights the need for this law to be addressed. It's important, but yet we don't want to throw the baby out with the bathwater. We don't want to hastily pass a revision of this very important law, and that revision opens up criminal prosecutions of select individuals without constitutional protections, depriving folks, targets of key constitutional protections, which this legislation has the potential to result in. This civil investigative demand that can be brought as part of an inquiry in preparation for a civil or a criminal case. That's a lot of power in the hands of a government bureaucrat that can be used as a fishing expedition against political opponents, misused, and enable civil, but most ominously, criminal prosecutions. This is not something that we should pass without due consideration of the consequences that would ensue from passage. And I ask my colleagues to ask themselves, what is the haste? Why are we rushing forward to give this kind of power to the Department of Justice under a Trump administration which is abusing and showing disrespect for the rule of law and showing the inclination to prosecute political opponents? Is it because we want to give the current Attorney General the power to prosecute political opponents? Is that why we're rushing this bill through right now? I ask my colleagues to ask themselves that question, and with that, I will yield back.
Chair, thanks, gentleman. Recognized himself in opposition to the amendment. Only to say, first, I want to correct my earlier statement. I think it was Tony Podesta. That would be more appropriate to name. But I don't think we should amend this to do that. I think that this is not the appropriate title for a bill like this. And I just say that when we have as many GAO reports and as many Inspector General reports and concerns, we should do this. And as to asking questions in a civil matter, it's certainly under all sorts of current federal law. If you ask a question in a civil matter that leads to information that could result in a criminal prosecution, unless there's a defense to answering that question in the civil matter, and civil discovery is very broad, I don't see that we're doing anything different here than we would be doing that already exists in other areas of the law. So I thank the gentleman for his concerns, but I think this is the appropriate thing to do and the right thing to do, and I must oppose the amendment with changing the title of the name.
Mr. Chairman.
Proposed gentleman from Maryland seek recognition.
Move to strike the last word.
Gentleman is recognized 5 minutes.
Thank you kindly, Mr. Chairman. First of all, I do want to salute the gentleman from Louisiana for bringing forward this legislation to amend the Foreign Agents Registration Act of 1938. It's long overdue, and recent events have focused our attention on the fact that there are major loopholes in the law, the most glaring of which, of course, is the fact that if you register as a lobbyist, you don't have to register under the Fara, and that simply makes no sense, and it becomes a built-in mechanism for camouflage of what a person is really up to. Having said that, I've got to join my colleagues in objecting to the massive process failure that we're seeing again on the committee. It would not be that difficult to have a hearing on the Foreign Agent Registration Act. There are lots of issues with it, and I think there's tremendous grounds for bipartisan compromise. A hearing wouldn't undermine our ability to create a consensus on the committee. It would strengthen our ability to create a real consensus on the committee, and we would come up with a much better product. I mean, you could think of whatever your favorite federal legislation is over American history, the Civil Rights Act, the Voting Rights Act, the Agricultural Adjustment Act, whatever it is, I challenge anyone to find a great act that was passed by the Congress without hearings to discuss what the real problems are, to try to manage the full complexity of the problem and the full magnitude of the issues. And so I feel bad that a very positive effort here looks like it's being immersed in the general partisan muck that seems to surround us in this Congress. But if we had a hearing and we could really discuss things, I think it wouldn't occur at the markup stage that people are raising problems for the first time. I do have one serious issue that I will raise in due course, but I wanted to yield to my colleague from Texas, Ms. Lee.
Let me thank the gentleman from Maryland, both for his astute analysis, and I too wanted to have this opportunity to make sure that Mr. Johnson knows that this is a very important issue and his initiative is an important issue, and I would hope that we would have an opportunity to engage in regular order. As Mr. Cicilline said, there are already existing bills. In addition, the National Association of Criminal Defense Lawyers has laid out a very important detailed analysis of the difficulty with the legislation. I ask unanimous consent, Mr. Chairman, to put the letter from the National Association of Criminal Defense Lawyers in the record.
Objection.
Thank you.
I think it's already in the record. But
If it is, it's double in, but thank you very much. But I chose to say no more, that's the naming of the bill, Paul Manafort or Michael Flynn's Act, and I think everyone would understand that. For Mr. Manafort, who registered retroactively as a foreign agent under Fara on June 27, 2017, months after it was revealed, he had provided services to Ukraine's pro-Kremlin party of regions and to former Ukrainian President Viktor Yanukovych from 2006 to 2015. And as part of the special counsel's investigation into Manafort and his colleague, Richard Gates, Manafort was charged with conspiracy to launder money, failing to register as an agent of a foreign principal for making false and misleading Fara statements. So he's an example of what we should not do. How do we know, without having hearings, that the present underlying legislation has covered all of the elements that would be necessary to ensure due process, but to cover issues dealing with Fara? So I think the point is well taken. I'm naming it because it fits aptly for the actions of these individuals that reflect globally and well understood. I don't think there's probably many in the world that have not heard of General Flynn and Paul Manafort. But it also speaks to this administration in a long litany of violations of the law and speaking the untruth, impacting foreign policy, in the week of Dr. King's birthday, being divisive and acting in a racial and racist manner, and again, putting a block in the way of legitimizing and legalizing 800,000 students, doctors, lawyers, individuals who finished school but are still designated as dreamers without status, jeopardizing their family and their future. So where are the hearings on those issues? Where is the legislation on those issues? The chairman knows how passionate many of us are on criminal justice reform. We've been trying over and over and over again to try and move that legislation forward. And in many of our districts, we get asked about that important work. So I do think this is an appropriate renaming of this bill. And I'd ask Mr. Johnson that he call for regular order so that the hearings can cover his legislation, other legislation, and certainly the potential good merger of good bills and good elements. So I'd ask my colleagues to support the Jackson-Lee amendment.
question occurs on the amendment offered by the gentlewoman from Texas. All those in favor respond by saying aye. Aye. Those opposed, no. No. Opinion of the chair, the noes have it. The amendment is not agreed to. Are there further amendments to H.R. 4170? For purposes, the gentleman from Rhode Island seek recognition.
Mr. Chairman, I have 4 amendments at the desk. I'd like to begin with
Pick one.
an amendment in the nature of a substitute.
If he wants to combine any of them, we would welcome that. But we will consider them one at a time, and the clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 4170 offered by Mr. Cicilline of Rhode Island. Strike all after the enacting clause and insert the following. Section
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This amendment in nature of a substitute would strike the language of H.R. 4170 and replace it with the language of H.R. 2811, the Foreign Agents Registration, Modernization, and Enforcement Act. To be clear, it is not because I have any great affinity for the authors of the bill, but this is a piece of legislation which is bipartisan here in the House, bipartisan in the Senate, and if we're serious about moving forward on modernizing Fara and reforming it, it has to be done in a bipartisan way, and that's what this bill does. It also is substantively different in the following ways. The bill that's before us provides for very expansive use of civil investigative demands, not just for the production of documents, which is how it's traditionally used, but for the compelling of testimony, for the compelling of written answers to questions. Those implicate a whole series of constitutional challenges in the context of criminal investigations, which the amendment avoids. This amendment recognizes the Department of Justice needs the ability to collect documents to begin civil or criminal investigations. It does so by creating a civil investigative demand authority related to documentary evidence. It specifically in page 3 protects against the demand for the production of documentary evidence that would be privileged if sought by a grand jury in similar circumstances. So it strikes the balance of making certain that, A, it's for purposes of document production, not expansively requiring compelled testimony, written interrogatories, which I understand this language was lifted from the False Claims Act, which is wonderful, but maybe doesn't have great application to a statute that has criminal components to it, unlike the False Claims Act. So this, I think this remedies that problem by making this a civil investigative demand. It doesn't extend to compelling written testimony or oral testimony. It expressly prohibits privileged materials from being the subject of a demand. It has an important reporting requirement, and it's bipartisan. I think this solves the problem of the Justice Department not having the civil investigative tool to get at information to help unravel the sources of this foreign registry or foreign advocacy in a way that doesn't implicate constitutional challenges, that ensures that in the Senate it's bipartisan and will accomplish this. And to be clear, I don't want to, I've had conversations with Mr. Johnson about my bill. I offered to him to be the lead Republican sponsor on it, so I'm not, when I first introduced it, and he declined and decided to write his own bill. So I'm only saying that this is more limited, which I think is the right approach. It avoids constitutional challenges. It's bipartisan in the House and the Senate. Let's on this day where we see so little bipartisanship, accept my amendment so we can make real progress on modernizing the Fara Act. And with that, I'll yield back.
What purpose does the gentleman from Louisiana seek recognition?
Mr. Chairman, I oppose the amendment, and
Gentleman is recognized for 5 minutes.
thank you. I do appreciate my friend and his effort. We have discussed this at length. To be clear, to correct his statement he just made, we have been working on this. I've been working on this for, I think, 8 months, since early last year. We were thinking along parallel lines and doing different work. I think the bill I've offered is superior to the amendment for a number of reasons. Look, there's long-standing provisions in current law that serve as the basis for my legislation. They have both civil and criminal liability while having CID authority. And the authority provided in this bill is limited in its delegation. It has a sunset on the authority. It includes probable cause provisions and specific oversight and reporting language. It's very tightly controlled, to put in a simple word. And you know, the efforts to object appear to be based against CID authority entirely, not just what's in this bill. According to the Congressional Research Service, no other CID authority in existence has this level of limitation or any warrant requirements. You know, we have worked on this in bipartisan fashion. It is a bipartisan bill. It's based upon, as we mentioned earlier, 50 years of history and request for this. And the DOJ has specifically requested that this use of the CID authority, because it will make the job easier, it will enhance enforcement of Fara, and it will pursue the underlying objectives of the legislation that's been a part of our law since 1938. The jurisprudence strongly shows that administrative subpoenas do not violate the Fourth Amendment, and based on a review of existing law, our legislation more than suffices to provide protections to challenge any government efforts that overstep their bounds. The language in question in my underlying legislation is, some of these examples is subsection K, judicial proceedings, Part 2, petition to modify or set aside a demand, K3, petition to modify or set aside a demand for product of discovery. There's a probable cause provision in place in my bill when federal investigators use the civil investigative demand authority. And it says at the bottom of page 3, lines 19 through 24, quote, whenever the Attorney General or the Attorney General's designee has reason to believe that any person may be in possession, custody, or control of any documentary material or may have any information relevant to an investigation under this act, unquote, then civil investigatory demands may be issued. This is standard language. It's used in CID provisions across the labyrinth of the federal government and the statutes, and it's much like the standard for filing a lawsuit and then being able to demand answers to questions from the defendant. The plaintiff just has to serve some basis in law or fact to file a lawsuit. So we've drafted this very carefully. It's gone through a number of revisions, hours and hours of discussion with all relevant parties, and I highlight again that it's supported by civil libertarian groups on the left and rule of law folks on the right. It's the right compromise. It has protections. It has a sunset provision. We'll be able to evaluate how well this is being used, and more importantly, if it's being abused in any way, and we'll correct those. But for all those reasons, Mr. Chairman, I oppose the amendment, encourage my colleagues to do the same.
For purposes, the gentleman from New York seek recognition.
To strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I'll be very brief. The gentleman from Rhode Island very ably explained his amendment. I support the amendment. It goes in the direction of the bill, but provides proper protections for CIDs. CIDs should not be used, at least not until we've further examined the question, but probably should not be used in the context of a possible criminal investigation, because they do raise significant Fourth Amendment concerns, and that is the big advantage of Mr. Cicilline'z amendment here. Mr. Cicilline'z amendment would make this bill constitutionally, I think, unquestionable. It would be a very useful amendment, very useful bill at that point, and I urge the adoption of the amendment. I yield back.
Question occurs on the amendment offered by the gentleman from Rhode Island. All those in favor respond by saying aye. Aye. Those opposed, no. Seeing the chair, the noes have it. Amendment is not agreed to. Are there further amendments?
Mr. Chairman, I have another amendment at the
Clerk
desk.
will report the amendment of the gentleman from Rhode Island.
Amendment to H.R. 4170 offered by Mr. Cicilline of Rhode Island. Page 3,
Without
beginning.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. This amendment strikes "or criminal" from the authority described in this legislation. Under the longstanding principles of the Fourth Amendment, the government generally cannot invade a person's privacy or seize their person or property without a valid warrant supported by probable cause. However, as it's currently drafted, H.R. 4170 would allow the government to administer a civil subpoena prior to the instituting a criminal proceeding by asserting merely that it has reason to believe a person has knowledge or documentation related to an alleged violation of Fara, Without requiring prior judicial review or probable cause, this provision of H.R. 4170 could be used by the government to undermine a party's constitutionally protected rights in criminal proceedings. And by striking the word "or criminal," it would bring this legislation in line with the Fourth Amendment and make the civil demand authority a civil enforcement proceeding. And so all the other concerns we have about compelling testimony, compelling written answers would at least be avoided by making this a strictly civil authority. And that's the reason for the amendment, and I urge my colleagues to support it.
For purpose, the gentleman from Louisiana seek recognition.
Mr. Chairman, I oppose this amendment.
Recognized for 5 minutes.
Thank you. Oppose this amendment, again, reiterating that so much work and effort has gone into this language, making it precise and specific. There's no history of abuses with regard to the concerns of Ms. Cicilline. Now, I will say that I'm willing to work with him, to continue to work with him on further enhancements to the bill as it moves along. But right now, the problem with adding these changes and these modifications that he's suggesting at this stage is that it might unnecessarily interfere in what the DOJ does in terms of enforcement of Fara across the board. They use other statutes, other federal statutes, when it comes to investigating and enforcing these provisions. And adding this right now, I just feel the risk would outweigh the benefits. Now, that said, again, I'm willing to work with him. We can work together on specific language going forward, but today I encourage my colleagues to avoid the amendment because we might add unnecessary complexity to a matter that's been discussed and deliberated and resolved over the last 8 or 9 months. I yield back.
Question occurs.
Mr. Chair.
The gentleman from Georgia seek recognition.
I move to strike the
I
last
was recognized for 5 minutes.
Mr. Chairman, I rise in strong support of this amendment. There is absolutely no reason why in the legislation that we're considering we should expressly give federal authorities the ability to use what's essentially a civil process to conduct a criminal investigation. Why would we give DOJ expressly that right to use a civil process, essentially a civil subpoena, an administrative subpoena, when they know that they are engaged in a criminal investigation? Why don't we require DOJ, as we do right now, to use its abundant powers to investigate criminal matters pursuant to their authority that they have now? It's sufficient. There's no need to enlarge the authorities upon which they can conduct criminal investigations. I think this is a dangerous step on a slippery slope, which can only go to the detriment of the constitutional rights of Americans. All Americans should be concerned about protecting constitutional rights. That's not a partisan issue. It should not be, but yet on this committee, when we have a very reasonable amendment such as this one, very simple, very reasonable, then we get a knee-jerk reaction in opposition simply because no Republican wants to go against the prevailing winds of partisanship. This is nothing, I'm not saying that this legislation doesn't deserve to be considered. It does. But why are we rushing through this kind of legislation, giving this kind of power to the federal government, particularly at this time when the persons who hold the levers of government show an inclination to misuse it? I strongly ask my colleagues to consider their positions and to be in favor of this amendment. And with that, I will yield back.
The chair recognizes himself in opposition to the amendment and yields to the gentleman from Louisiana, Mr. Johnson.
Thank you, Mr. Chairman. I just want to add one example to address the concerns and the reasons why I would oppose this amendment. Case in point is the Racketeer, Influence, and Corrupt Organizations Act of 1970. All of us are familiar with RICO, what an effective and important tool that has been for the Department of Justice and for the rule of law in this country. RICO allows the Justice Department's organized crime and gang section of the criminal division to institute criminal penalties and a civil cause of action for acts performed as part of an ongoing criminal organization. Now, CIDs have been an essential component in RICO's success, and no changes have been made with respect to the DOJ CID power with RICO. It's an example of how this has been used very effectively and not abused. It's an essential tool. I just want to note, by the way, that RICO was passed in a strong show of bipartisan support. The House passed the bill by a margin of 341 to 26, and the Senate passed that bill 74 to 1. All of us know it's an extremely effective tool. It's a good, I think, example of how this can be done without abuse. And again, in this bill, if it is abused in this arena, which we do not anticipate and don't expect, we can fix it. We have the ability to do that.
Would the gentleman yield?
I yield.
It's one thing to use the criminal process and at the same time a civil process be rolling down the track concurrently or simultaneously, but then it's another thing to use the civil process to conduct a criminal investigation simultaneously. That's the difference. And I'd ask that, that we strongly support this Cicilline amendment.
Thank you. I reclaim my time. I understand the difference very well, and I'm suggesting to you that we do not allow a margin for the abuse here. We could correct it later if there is, but I don't believe there is, and all the experts who have looked into this, again, on the right and the left, agree that this is an appropriate measure whose time has come.
Would the gentleman yield?
I'll yield.
It would really be wonderful for us to hear from these experts in a hearing and have them subject to examination by the reasoned members on this committee so that we can arrive at a truly bipartisan piece of legislation to deal with this need that is glaring. I want to commend the gentleman for bringing forward the legislation, but I just want it to be handled in the normal course.
Reclaim my time. I appreciate my colleagues' insistence on the details, and I would just suggest to you, in this particular case, there may not be a need for exhaustive hearings and oral testimony. The reason being is, as we mentioned, we have almost a half century of detailed, specific written reports about the failures and the problems with this law, its enforcement, its comprehensive strategy. This legislation directly targets that. It's based on bipartisan support, and with that, I yield back and pose the amendment.
Mr. Chair.
First, the gentleman from Maryland, seek recognition.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you very much. I rise in favor, very strong favor, of the Cicilline amendment. I'm afraid without it that this language is a sitting duck constitutionally and would be struck down immediately by a federal court. And I would hope the author of the bill, which I think is otherwise very strong, should reconsider. The Fourth Amendment provides that no warrant shall issue but upon probable cause supported by oath or affirmation. This language says, whenever the Attorney General has reason to believe that any person may be in possession, et cetera, of relevant evidence, the Attorney General may, prior to the institution of a civil or criminal proceeding. That's in glaring violation of the Fourth Amendment, right there. And I think all the amendment does, as I understand it, it removes two words, or criminal, in order to guarantee the constitutional seaworthiness of this vehicle. I think the RICO analogy is unavailing here. As I understand it, the argument is that because there can be a civil proceeding under RICO and also a criminal proceeding, that somehow vindicates this arrangement. But civil actions under RICO are brought by private citizens, where private citizens allege that there are a series of predicate offenses under extortion in the Hobbs Act, conspiracy and so on, relevant criminal offenses, and that they've been civilly damaged by it, and then they bring a civil action. But they don't have the authority to use the state, or put it differently, the government doesn't have the authority to bring a civil action and then use that evidence in a criminal prosecution against someone. So I do think that this is an invitation to strike the whole thing down, and I'm going to speak in very strong favor of the Cicilline amendment because I want to be able to vote for the bill. I yield back, Mr. Chairman.
Question occurs on the amendment. For purposes, the gentlewoman from Florida seek recognition.
Thank you so much, Mr. Chairman. Move to strike the last word.
Gentlewoman is recognized for 5 minutes.
I speak or rise in strong support of the Cicilline amendment. You know, as someone who served in law enforcement, I certainly commend my colleague and my classmate for revising and updating this particular statute. However, I believe that we really have to be very, very careful whenever we expand the ability to use a civil process in a criminal investigation. What makes this country beautiful are the protections that are given to every individual guaranteed by the Fourth Amendment, the right to due process. The standard in a criminal case and a civil case are clearly different. In a criminal case, we are not talking about preponderance of the evidence or clear and convincing evidence. We are talking about probable cause. So for that reason alone, if we just stop right there, I believe that the amendment offered by the gentleman from Rhode Island is quite appropriate, and I rise in support of that amendment. Thank you, Mr. Chairman.
Question occurs on the amendment offered by the gentleman from Rhode Island. All those in favor respond by saying aye. Aye. Those opposed, no. No. Opinion of the chair, the noes have it. The amendment is not agreed to.
Request a recorder vote,
Recorder
Mr.
vote is
Chairman.
requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. Farenthold votes aye. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Mr. Rutherford votes no. Ms. Handel? Ms. Handel votes no. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Ms. Demings? Ms. Demings votes aye.
The gentleman from Colorado.
Mr. Buck votes no.
The gentleman from Texas.
Mr. Ratcliffe votes no.
The gentleman from Texas, Mr. Smith.
Mr. Smith votes no.
The gentleman from Idaho.
Mr. Labrador votes no.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 10 members voted aye, 12 members voted no.
And the amendment is not agreed to. Are there further amendments?
Mr. Chairman, I have an
Gentleman
amendment.
from Rhode Island seek recognition. The clerk will report the amendment.
Amendment to H.R. 4170 offered by Mr. Cicilline of Rhode Island. Page 20, beginning line 17, striking nothing in this subparagraph and all that follows through line 23.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. I have this final amendment at the desk, which I'm hoping is one more attempt to save this piece of legislation from being struck down as unconstitutional. This amendment in particular would put limitations on what the Justice Department can do with information it obtains from a civil investigative demand to enforce compliance with Fara. Civil investigative demands permit the government to obtain records without a court or a grand jury. Many kinds of administrative subpoenas, such as the one created under the current bill, allow government agencies to obtain records in order to ensure compliance by a party that is subject to its regulations. Courts have consistently held that the issuance of an administrative subpoena without a showing of probable cause does not violate the Fourth Amendment because it's less intrusive than a search and seizure that necessitates a warrant. In addition, the Supreme Court has recognized that an administrative subpoena should not be subject to a probable cause determination because they are often used as information gathering tools for the very purpose of determining whether probable cause exists. Although these subpoenas have a basis in law, civil liberties advocates also have a legitimate concern that administrative subpoenas can lead to government's abuse of authority. If left unchecked, administrative subpoenas can be used to get around the Fourth Amendment and to subject individuals to investigations unrelated to the basis of the subpoena. My amendment would address these concerns by prohibiting information obtained through a civil investigative demand. And I call your attention to the civil investigative demand. This is what it is. It is not a criminal investigative demand. It's a civil investigative demand. Under this act, from being used for any administrative or civil action that does not directly arise out of an alleged FARA violation. For example, if DOJ subpoenaed a foreign agent's bank records to verify its funding sources, my amendment would prevent the DOJ from turning around and providing those records to the IRS for a civil or criminal tax evasion case. In addition, my amendment would entirely bar the use of information obtained through a subpoena under this bill for use in any criminal action against the individual. This would stop the government from using FARA civil investigative demands to bypass the Fourth Amendment probable cause and warrant requirements, which are paramount in a criminal case and required by our Constitution. The latter is an important element because investigations can and do shift from civil to criminal investigations based on the progress of the investigation. When this shift takes place, the government must ensure that the investigation satisfies Fourth Amendment standards. My amendment would preserve the information gathering utility of administrative subpoenas while providing an important check against abuse by the Justice Department and other government agencies. So this will really ensure that civil investigative demands are used for the purpose for which they were created, to gather investigations for a civil enforcement proceeding and bar their use in a criminal proceeding. Now, it does include in the second page of the amendment nothing precluding a law enforcement agency from gathering through their regular process, whether it's a warrant, a subpoena, a grand jury proceeding, the same information. So they would still be entitled to investigate and proceed with criminal prosecutions, but they wouldn't be able to use the civil demand production as a way to skirt the requirements of Fourth Amendment. If my colleague and friend is serious about doing this in a way which respects the Fourth Amendment and protects this from being struck down as unconstitutional, this limited use amendment will provide that answer, and I certainly hope he will support my amendment, as will my colleagues. And with that, Mr. Chairman, I yield back.
What purpose does the gentleman from Louisiana seek recognition?
Thank you, Mr. Chairman. I oppose the amendment.
Gentleman is recognized for 5 minutes.
Thank you. We're making similar arguments for all these amendments, and I don't want to repeat myself just for the sake of it. But I do just want to reiterate that what we're doing here is supported by the Office of the Inspector General's recent report, multiple GAO reports, and civil liberty groups, and that we have sections in here that add CID limitations and oversight. The OIG's recommended suggesting additional controls on CID. We've done that. The provisions here are the product of 55 years of refinement to these provisions and included in previously passed bipartisan legislation. We've got a sunset provision. I just don't believe that what is being suggested as areas of abuse are real concerns. Based upon—
Will the gentleman yield?
Wait, let me finish. Based upon more than a half century of experience in the federal government and with the use of these. I understand that you're saying we're doing something novel here. What I don't want to do with the amendment today is add in complexity that has not been vetted properly by the DOJ, by the OIG, all the interest groups. We've been working on this very carefully, as I said. I reiterate, I'm willing to work with you going forward as we move it to the floor and move it through the process. But for today, I have to oppose the amendment because I fear, though I understand it's not intended by my colleague, this is done in good faith, it could wind up being in some way a poison pill on the legislation. So for that reason, I oppose the amendment, urge my colleagues to do the same. I yield back. I yield to you.
Oh, I thank the gentleman for yielding. I would just say that the suggestion that we have a half century of experience, we have almost 300 years of experience with the Constitution, and it's not a question that, well, it's sunsetted, so if there's some violation. The Fourth Amendment is a current obligation we have to honor and respect and pass laws consistent with. So the notion of, like, people might not abuse it, or for 50 years we've tried it. Our Constitution and Fourth Amendment requirement has existed much longer than 50 years. And all this is saying is, I certainly hope it is not your intention to create a statutory authority to compel the production of documents, compel the testimony of an individual, or the written answers to a question, and then use that without any finding of probable cause or any finding of a judicial review, compel the production of that, and then use it for criminal prosecutions. You will have eviscerated the Fourth Amendment. And the notion that you don't think people will do it, or we have other contexts in which there hasn't been abuse, doesn't address the fundamental obligation we have to pass legislation that doesn't violate the Fourth Amendment. So I just asked the gentleman.
Would the gentleman from Louisiana, without objection, the gentleman's granted an additional minute. Would the gentleman from Louisiana yield so I can respond to the gentleman from Rhode Island?
Of course.
So this happens in all kinds of civil cases where information is requested. It happens right here in the United States Congress where information is requested that somebody may not want to reveal because it may imply criminal obligations. And, you know, there's the Fifth Amendment as well as the Fourth Amendment, which people can exercise if they feel the need to do that. But civil discovery is not an unreasonable thing for any government agency to use if it's used appropriately. And I don't see how these guidelines are in any way inappropriate here as they are in a whole host of other places where they're used.
Move straight.
Gentleman from
I'm happy to. You want to go first? Mr. Chairman, I would say in response to that, because the underlying legislation doesn't have an express provision, as was in the bill I attempted to use as a substitute, that recognizes the right to the assertion of a privilege, the concerns about the use of a civil demand authority in a civil proceeding is quite different than allowing the government to compel the production of documents, testimony, and evidence that then can be used against that person in a criminal proceeding. I mean, you're the chair of the judiciary. You surely don't think that that's appropriate.
But no, but the assertion of a privilege is a constitutional right. It's not a right set forth in statute.
No, but it has to recognize the inability to use the civil demand in the presence of those assertions.
I'm opposed to the amendment in its form. I would reiterate what the gentleman from Louisiana has said, that if we carefully review this in terms of all the different concerns, we're more than happy to work with you. We think your intentions are well intended, just as the gentleman from Louisiana's are. But in the current legislation, I don't think it would be helpful to pass this amendment.
Mr. Chairman.
Mr. Chairman.
Where's the gentleman from New York seek recognition?
Strike the last word.
Gentleman's
Mr.
recognized for
Chairman.
5 minutes.
Thank you. I'll be very brief. I won't use the 5 minutes. Let me just say that I support this amendment in light of the fact that we are specifically expanding CIDs in areas which could have criminal prosecutions. This limitation on the use of the information from them, I think, does protect the constitutionality of the underlying legislation and does go in accord with our basic principles. Yes, civil discovery, data obtained in information obtained in civil discovery can be used in criminal cases, but the difference here is that we're setting up specific procedures for civil discovery aimed at what may be criminal proceedings, and that seems to go in the wrong direction and implicates some constitutional problems. I therefore support the amendment. I yield back. Unless the gentleman I'll yield to the gentleman from Rhode Island.
I just want to answer thank the gentleman for yielding. I just want to answer the gentleman's question, the chairman's question, because in the Foreign Agents Registration Modernization and Enforcement Act, we specifically included a provision that says a demand under this section may not require the production of any documentary evidence that would be privileged from disclosure if demanded by a subpoena ducis tecum issued by the Court of the United States in aid of a grand jury investigation of such alleged violation. So there's an expression. That was removed, that was not included in the underlying bill offered by Mr. Johnson. That was replaced with, on page 8, that says a civil investigation demand under this section may not require the production, and it says the standards applicable to discovery requests under the federal rules of civil procedure to the extent, blah, et cetera. So they get rid of, they don't include this protection against disclosures of stuff that would be privileged to a grand jury, and they replace it with a reference to the rules of civil procedure. That's not adequate protection. And so you are, by passing this bill in its current form without this protection, are allowing the government to compel not just the production of documents, but the production of testimony from an individual, require them to answer written questions, and all of that can be used to criminally prosecute them with no compliance with the Fourth Amendment requirement. That is clearly not permitted by the law.
Would the gentleman from New York yield? Do I respond to the gentleman?
Would I yield? Yes.
I thank the gentleman for yielding. I just want to say that what the gentleman states is correct, but it's stated in the United States Constitution and in prior law. It does not need to be restated that the Constitution applies here.
Would the gentleman yield?
I'll yield to whom? To the gentleman from Maryland.
Thank you very much. Just to intervene in this colloquy for a second, there is no Fifth Amendment defense to a Fourth Amendment demand for production of physical or documentary evidence. And the Supreme Court has repeatedly said you can't say, I'm not going to turn over these materials because they could implicate me in a crime.
But you need a warrant for that.
Well, right, you need a warrant under the Fourth Amendment.
Correct.
Exactly, that's our whole point. I think that's why Mr. Cicilline'z amendment is necessary here, because you need a criminal warrant in order to obtain evidence, a criminal warrant based upon probable cause in order to obtain evidence that can be used against someone in a criminal prosecution. And what happens in the language of the gentleman from Louisiana's bill here is that there's a bridge. So you get the evidence on the civil side with a mere reasonable cause standard, and then you walk over the bridge behind the scenes and you give it to the criminal prosecutors, and then they use it to prosecute someone. And Mr. Chairman, if I could, whose time am I on? I'm sorry.
Fine.
If I could continue just for a second. I mean, Washington is an interesting place, because had we suggested giving this power, for example, to the special counsel, where the special counsel could, on a civil standard, make a demand, say, of Mr. Manafort or any of the Trumps on a civil basis, and then take the evidence and then turn it over for criminal prosecution, they would be yelling not only witch hunt, but that this is a complete destruction of the Constitution. And I certainly hope that I would have the courage of my convictions and the principles to stand with you in saying that's completely unacceptable. So I don't see why we would turn around now and say that's somehow a novel exception that should swallow the entire rule of the Fourth Amendment. So again, I would just urge my colleagues to rethink this one small part of a very good bill in general, but I do think that it taints the entire bill and it risks it being struck down for being a complete violation of the Fourth Amendment.
I agree with the gentleman from Maryland, and I'll yield to the chairman.
I thank the gentleman for yielding. I just want to say to the gentleman from Maryland that this has been the standard in RICO cases for decades.
The gentleman yield. What has been the standard? I'm not following. Under RICO, probable cause operates.
This bill tracks the exact same language in the RICO statute, the civil RICO statute.
Okay, under the civil RICO statute, again, as I understand it, is that if I believe I've been injured by people engaging in a pattern of racketeering activity, including extortion, conspiracy, embezzlement, other felonies, I can bring a civil action against them. But I need to prove those are predicate offenses. All I need to prove is that they've been convicted of those offenses before.
Let me read to you, if I may, without objection, the gentleman from New York is recognized for an additional 2 minutes. Let me just read to you from the RICO statute. Whenever the Attorney General has reason to believe that any person or enterprise may be in possession, custody, or control of any documentary materials relevant to a racketeering investigation, he may, prior to the institution of a civil or criminal proceeding thereon, issue in writing and cause to be served upon such person a civil investigative demand requiring such person to produce such material for examination. Now, given that that's current law, to make the change suggested by the amendment of the gentleman from Rhode Island would cause serious conflict and disruption to our standards today. And therefore, I must oppose that amendment. Notwithstanding that, to assure both the gentleman from Rhode Island and the gentleman from Maryland and the gentleman from New York that we're doing everything that's appropriate under the law and the Fourth Amendment to protect individuals, we're more than happy to continue that discussion with you if there's some language that does not upset the apple cart to meet that concern. But this amendment doesn't accomplish that, and I must oppose it.
I yield to the gentleman from Maryland.
If I just might question the chairman about that, I understand that the provision you've cited is limited to the authority of issuing a civil investigative demand for civil action under RICO, not for a criminal prosecution. Is it?
It says, he may, prior to the institution of a civil or criminal proceeding thereon, issue in writing and cause to be served upon such person a civil investigative demand, and it continues.
Reclaiming my time, let me just comment very briefly. I support the gentleman's amendment. The chairman's reading from RICO leads me to suspect that perhaps we ought to take a close look at RICO. Maybe it goes too far in the Fourth Amendment. And the fact that you have a law in one area that perhaps goes too far should not be used as a predicate for expanding the law in the wrong direction in a different area. I yield back.
Gentlemen, yield.
First of all, this is not unconstitutional, but the gentleman wants to revisit that language. Let's find language that's agreeable here, and then maybe it will be applicable there. But I am not in agreement that there's anything wrong with the language that is in this current legislation right now, but I'm certainly happy to have further discussions to assure you that there's nothing wrong with it as well. With that, the question occurs on the amendment offered by the gentleman from Rhode Island. All those in favor respond by saying aye.
Aye.
Those opposed, no.
No.
No. Opinion of the chair, the noes have it. The amendment
Request a recorded vote, Mr.
Recorded
Chairman.
vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Smith votes no. Mr. Shabbat?
You know, we have had from both sides people shouting from the cloakroom. We've been tolerant of that when they shout in response to their own name, but when they shout in response to someone else's name, we have to back up and begin the roll call again.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Ratcliffe? Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Mr. Rutherford votes no. Ms. Handel? Ms. Handel votes no. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Ms. Dimmings? Ms. Dimmings votes aye.
Gentleman from Colorado, Mr. Buck.
Mr. Buck votes no.
Gentleman from Texas, Mr. Ratcliffe.
Mr. Ratcliffe votes no.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 8 members voted aye, 16 members voted no.
And the amendment is not agreed to. Are there further amendments to H.R. 4170? Does the gentleman from Maryland seek recognition?
Thank you, Mr. Chairman. Again, I want to restate my my general agreement with the thrust of this bill and my admiration for Mr. Johnson for bringing it forward and Mr. Cicilline for making this an issue. I think we must use this as an opportunity to clean up some potentially fatal vagueness in the definitional section, section 6 of of the underlying Foreign Agents Registration Act of 1938. And I've got an amendment at the desk.
Amendment to H.R. 4170 offered by Mr. Raskin of Maryland. Page 34, insert after line 8, the following new section.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Mr. Chairman, thank you. So what we're in the process of doing with the gentleman from Louisiana's bill is strengthening the Department of Justice's ability to enforce the Foreign Agents Registration Act of 1938. In the process, I think we need to clean up a problem in the definition section, which I think is potentially fatally vague to the underlying statute. The common sense understanding that any of us would have about a foreign agent is the same understanding that's embodied in principal agent law, which is someone who's acting under the direction or control of another person. But this language applies to anyone who is acting at the order, request, or under the direction or control of a foreign principal or of a person, any of whose activities are directly or indirectly supervised, directed, controlled, financed, or subsidized in whole or in part by a foreign principal. So the purpose of this amendment is simply to simplify it to say under the direction or control of a foreign principal or of a person directed or controlled by a foreign principal, which is both the common sense and common law understanding of what a foreign agent is. Without that, again, I'm afraid that no matter how upset people are about what we've seen in recent revelations in the news, we are going to go way too far. So take, for example, the example that's probably on a lot of people's minds, which is the meeting that took place in Trump Tower with Natalia Veselnitskaya and other Russians who came to speak with representatives of the Trump campaign. Now, should everyone who was in the room in the Trump campaign have had to register as a foreign agent simply because they responded to a request from these people that they, for example, oppose the Russian sanctions? And I don't think that should be enough to compel someone to register as a foreign agent. Now, if they're acting under the direction or control of the Russian team that was assembled, yes, then by all means. But if there's simply a request made to them, will you please work against the sanctions that were put in by the prior administration, and they agree to do it, I don't think that that should subject them to the requirement to register as a foreign agent, punishable by years in jail and so on through a knowing violation. Similarly, you could find in another context if Amnesty International asked a group in America to have a fundraising concert to raise funds for political prisoners in, you name it, Saudi Arabia, Turkey, whatever country, and they hold a concert, I don't think answering that request makes them a foreign agent. Now, again, if they're acting under the direction or control of a foreign government, then by all means, they should be included. But I just think that we're opening this up way too wide if we're strengthening the ability of the Department of Justice to compel registration under Fara, which we should do, but we're not being very precise about who is swept within the definition. So with that, I would submit it to the wisdom of the committee, and I hope that Mr. Johnson would see the logic of cleaning this up at this point.
I thank the gentleman, recognize myself in opposition to the amendment, and let me explain why. None of the published Inspector General reports that we've referenced today have called for a change to this provision, and I think that's important because making changes to the definition of an agent of a foreign principal could have dramatic consequences on how the law is enforced. The amendment would limit and narrow the definition. Obviously, I know that's by design, but as such, it's reasonable to expect the amendment would lead to non-compliance with FARA like we've seen with the LDA exemption. Let me give you a specific example that's been cited to us. This amendment could weaken FARA and create a loophole for bad actors to exploit. This is the example. Under this potentially new definition, a U.S.-based subsidiary of a foreign company could potentially donate to a charity that then engages in political activities and thus avoids FARA registration. FARA loopholes have been highlighted in OIG reports for decades, and Congress should not draft legislation that makes it easier for individuals and entities to subvert the law. And I'm concerned that this amendment, while I know well-intended and offered in good faith, might have the unintended consequence of that. Our aim with H.R. 4170 is to strengthen FARA enforcement and increase compliance. I know you agree with that objective. And I just feel this amendment would accomplish neither of those things. The Department of Justice has not issued any recommendations regarding the definitions, and we could consult with them, but this is another one that I would commit to you on the record to work with you going forward if there is a way to do this that would not weaken the compliance with the law, the enforcement of the law. So far as DOJ is concerned, I would be willing to do it, but at this point, have to oppose the amendment for that basis.
Would the gentleman yield?
I will.
Thank you very much, and thank you also for your stated willingness to work with me in terms of dealing with the potentially fatal vagueness and overbreadth of this provision, especially if we get into an era of much more muscular enforcement, which I hope we do. The problem that you identify about the funneling of foreign money is one I take very seriously. In fact, I've got legislation to deal with that called the Get Foreign Money Out Act in order to address a loophole that was created by Citizens United, which of course turns every corporate treasury into a potential political slush fund, thereby allowing foreign governments and corporations and businesses, by taking over a business or taking over a large part of a business, to channel money into our politics. And I think that that's a much more direct way of dealing with the problem that you've identified, rather than essentially classifying anybody who's involved with international organizations or foreign businesses as a foreign agent. So again, I think that this is a problem that we're going to have to deal with eventually, if not now. I appreciate your willingness to work with me on clarifying the issue, but I think when we talk about foreign agents, we're really talking about people who are acting under the direction or control of a foreign government, and not someone who simply responds to a request by any foreign entity. And again, that would, I think, clearly make, at least based on published accounts, everybody who was in the room at Trump Tower a foreign agent, to the extent that they acted in response to a request made by the Russian foreign nationals who were present in the room. So, again, I would submit the amendment, and I thank you for your consideration, Mr. Chair.
To reclaim my time, just want to make a note for the record that my bill doesn't change any definitions in the underlying statute, and of course yours would, and that's one of the bases for my opposition to the amendment. Question occurs on the amendment. All those in favor say aye.
Aye.
All those opposed? Opinion of the chair, the noes have it. The amendment is not agreed to. Are there any further amendments?
Mr. Chairman,
Yes.
I have an amendment at the desk.
Ms. Jayapal.
Thank you,
Recognize
Mr.
5
Chairman.
minutes.
Thank you, Mr. Chairman. I'd like to thank you for bringing this bill forward. I think we all understand how important this issue is, and I also want to thank you and your office for your work with us. We have
Ladies, suspend for just a moment. I apologize. Clerk needs to report the previous amendment.
Amendment to H.R. 4170 offered by Ms. Jayapal of Washington. At the appropriate place, insert the following. Report to Congress.
Without objection, the amendment's report is read. Ms. Jayapal, may continue. Sorry.
Thank you, Mr. Chairman. As I said, I appreciate the work that you and your office have done in reaching out to us. We would have preferred that there was a hearing but I do think you have made many attempts to try to reach out to us. I also want to thank Mr. Cicilline for his long-standing work on this issue and for his bipartisan bill that is also introduced into the House. And I think that there are some still serious concerns around Fourth Amendment protections in this bill that really do need to be addressed one way or another. And I'm disappointed that we were not able to accept one of Mr. Cicilline's amendments that would have at least started to address this issue. And I hope that if this legislation proceeds, that we can continue to work with you and your office to really address that, because it is a significant issue for many of us, and I think that it limits the ability for us to be as bipartisan on this bill as we all would hope to be. The Foreign Agents Registration Act of 1938, as you and others have said, has long been in need of reforms to ensure that foreign agents are following our laws. FARA is intended to increase public transparency of the activities of foreign governments attempting to influence U.S. policy, but the enforcement is entirely dependent on voluntary registration, disclosures, and record-keeping by the people that FARA seeks to regulate. And I don't think we can expect bad actors to independently follow our laws to help us to conduct oversight of their actions. So it is important for the strength of our democracy that we make improvements to FARA so that we are less dependent on people we are regulating to follow our laws. Certainly over the last few years, we've seen more and more evidence come out indicating the critical need to conduct robust oversight of foreign agents seeking to influence U.S. policy. The evidence of Russian interference in our elections and democracy raised serious concerns, and it is our duty as members of Congress to ensure we do everything we can to defend our democracy. Mr. Chairman, my amendment would require the Department of Justice to report to Congress within 2 years on the steps that they've taken to make use of electronic filing of all reports in a digitized format, which in turn would then make the FARA website database fully searchable, sortable, and downloadable. The events of the past year have truly illustrated how important it is for us to exercise this proper oversight, and we've watched as high-ranking members of the administration and the President's inner circle have fallen, and as Special Counsel Mueller has uncovered evidence around potential obstruction of justice and collusion. For example, former National Security Advisor Michael Flynn retroactively filed a FARA registration indicating that he was paid more than $530,000 to serve as a lobbyist for the Turkish government while working as a Trump campaign advisor. And it was also revealed that Mr. Flynn was working on a $15 million plan to kidnap a political enemy of Turkish President Erdogan and fly him to an island prison. This has all occurred as we've witnessed a dramatic reduction in overall FARA registrations. Since the mid-1990s, we've seen a 60% drop in registered FARA lobbyists and a 73% drop in registered foreign principals. According to a 2016 audit by the DOJ's Inspector General, there is a general disregard for timely filing and accurate reports among those who have registered, and the DOJ has only pursued 7 criminal enforcement actions for FARA violations over the last century. So, Mr. Chairman, I appreciate your bringing forward this bill. I hope that you'll accept this friendly amendment, and I hope that we can resolve these Fourth Amendment protection issues that I think would bring many of the Democrats on our side of the aisle along, because we all do believe that this is a critical issue that you've brought forward. So with that, I thank you and I yield back.
Thank the gentlelady from Washington. I do agree the amendment's a good one and do accept it and encourage our colleagues to do the same. I'm for further disclosure, for more disclosure, as you are. I think this will help. I think the electronic filing of all reports in a digitized format will assist in that effort, and so for that reason, I urge my colleagues to support it. With that, question occurs on the amendment. All in favor say aye. Aye. All opposed? Opinion of the chair, the ayes have it. The amendment is agreed to. Any further amendments? If not, the question is on final passage of the bill as amended. Reporting quorum being present, the question is on the motion to report the bill, H.R. 4170, as amended favorably to the House. Those in favor say aye. 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 Those opposed?
No.
Independent of the chair, the ayes have it, and the bill is ordered reported favorably.
Yeah, Mr. Chairman, on that, I ask for the ayes and nays.
A recorded vote's been requested. The clerk will call the roll.
Mr. Goodlatte? Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes aye. Mr. Shabbat? Mr. Isa? Mr. Isa votes aye. Mr. King? Mr. King votes aye. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Farenthold votes yes. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Johnson of Louisiana?
Aye.
Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Rutherford? Mr. Rutherford votes aye. Ms. Handel? Ms. Handel votes yes. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Ms. Demmings? Ms. Demmings votes no. Not recorded.
Mr. DeSantis.
Mr. DeSantis votes yes.
Mr. Gomer.
Mr. Gomer votes yes.
Mr. Ratcliffe.
Mr. Ratcliffe votes yes. What about Gates? You stuck in Houston? Yeah. No.
Gentleman from Ohio.
Mr. Shabbat votes aye.
Clerk will report.
Mr. Chairman, 15 members voted aye, 6 members voted no.
The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and the staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all our members for attending. The markup is adjourned.